Hi, well, good afternoon if you're on the East Coast, and good morning if you're way out west. My name is Aaron Lacey, and you are listening to Soup to Nuts, a review of the One Big Beautiful Bill higher education provisions. And we're just going to say OB3 for the remainder of this presentation. I know there's still a lot of discussion out in the world about how folks are going to refer to this thing, but I'm hearing from the Beltway that the cool kids say OB3, so that's what we're going to go with. This is part of a three-part series that we're offering. The first is today. We're doing another webinar this coming Thursday and another one next Tuesday. On Thursday of this week, I'll be talking about and really doing an in-depth discussion of the new accountability framework, though we'll be covering that today just as part of the soup to nuts. And then next Tuesday, I'll be sitting down with Chris Murray, who's the chair of our lobbying and policy practice. And Chris is going to spend about an hour just talking to us about sort of the political environment in which this legislation came about, but then also sort of looking forward what we think may be down the road. Thompson Coburn, if you do not know us, is a law firm. We have a little over 450 attorneys nationwide at offices in various markets across the country. And we have a higher education practice, which means we have a group of attorneys who spend all or most of their time serving institutions of higher education. My name I mentioned is Aaron Lacey. I'm a co-chair of the higher education practice and an attorney here in the firm. And I spend all of my time serving institutions of higher education. And in particular, I'm a regulatory and policy guy. So when things like this new piece of legislation come along, or all the rulemakings that we anticipate are soon to follow, in fact, we know are following, I spend a lot of time with my nose in the Federal Register and the United States Code and all those kinds of things. Okay, final couple of preamble disclosures here. Just keep in mind, things are fluid right now, as you know, with executive orders, and even with this statute, the changes that this statute has made are going to be there for a long time. But how those statutory changes are interpreted, the rulemakings that we already know have been announced, there's a lot coming your way. So if you're watching this presentation on YouTube or somewhere after today, just keep in mind, if it's past August 2025, there could be changes that have taken place, and you want to be on the lookout for those. I mentioned earlier, all the hyperlinks in this PDF, which you can download from the resources widget, are live. And in presentations like this, where we're covering a lot of ground, we try to give you citations and links to underlying resources. Finally, with regard to our resources, we do a lot of compliance guides. We have all these types of presentations. All of that is in one place now. It's on our Regucation platform, and you can get there by scanning the magic QR code. Or if you're like me and you're old-fashioned, you can just click the link there that says here. Here's the syllabus for today. I'm going to start with just a quick review of the OB3 architecture. For me, it's really important to understand that. And sometimes when you read other guides and summaries, you don't have a sense of like, well, where is all of this in the legislation itself? And I wanted to give you just a little bit of that. And then we're going to march through the subtitles. That's another reason I wanted to start with the architecture, so it gives you sort of a roadmap. We're going to talk about exemption of certain assets. That's very brief, but it's about the FAFSA, loan limits, loan repayment, Pell grants, accountability, regulatory relief. I'm going to do a little lagniappe here at the end. I'm a Louisiana guy, lagniappe means a little something extra. I'm going to talk about the new endowment tax framework, just one slide. It's not actually part of the subtitles I've been referring to, but this is supposed to be soup to nuts. And then finally, we'll try to hit on negotiated rulemaking to the extent we had time. So let's start with that OB3 architecture. So I'm talking about the act itself. It was signed into law July 4th, 2025. Again, this is the One Big Beautiful Bill Act. I'm just calling it OB3 to make life simple. It also goes by public law number 119-21. You can get to the text if you click there. You can also click on the picture here, and you can pull up the text at congress.gov. Just make sure if you go to congress.gov that you're actually looking at the final enrolled version of the legislation, right? Because they have their earlier versions of it. I just want to make sure if you're pulling it, you're getting the thing that actually became the law. So if you were to look at that legislation, if you pull up the act, you could go to the table of contents there at the beginning, and you would see it's organized into 10 different titles. And here are all of the titles, and each one basically reflects a Senate committee, right? So you see like the Committee on Agriculture, Nutrition, and Forestry, Committee on Armed Services. And if you get down to Title VIII, you see the Committee on Health, Education, Labor, and Pensions, the HELP Committee, right? And as you would expect, it's within that Title VIII that you find the higher education stuff that we care about. So, or at least that's the subject of today's webinar, I should say. I'm sure there are other things that you care about. So within Title VIII, there are 6 subtitles. So again, if you go to the Act, right, you'll see it's organized into 10 titles. The higher education stuff, for the most part, is in Title VIII. And within that structure, you've got 6 subtitles, right? And that's the exemption of certain assets, loan limits, loan repayment, Pell Grant, accountability, which is the new do no harm framework. You may have heard that phrase used. And then finally, regulatory relief, which has to do with the bar defense and closed school loan discharge stuff. You see, I tried to put that in parens there for you. So the way this presentation is organized today is we're just going to march through these different subtitles. And I mentioned earlier, if you go to those red lines, what you'll see is red lines showing the changes that were made by subtitles B, C, D, and E. A and F were very short, and again, didn't actually make changes to the code itself. So let's start with exemption of certain assets. And the first 2, 3, 4 of these subtitles are more on the financial aid side. Again, this is sort of nuts and bolts, Pell Grants, loan limit, the loan repayment framework, right? And then the last back end of it, we get into the accountability framework and the regulatory relief, which is more on the sort of financial value transparency, gainful employment / do no harm, and then bar defense and closed school loan discharge, those types of things. But we'll start with the FA-centric ideas. And by the way, quick shout out to the NASFA team. I had the opportunity to review. They put together, I think it's about a 3-page chart. You can probably still access that on their website. Boy, it's wonderfully succinct and really captures the essence of all of these changes that relate to, in particular, the federal financial aid nuts and bolts concepts, right? Like the loan limits and the changes to Pell Grant and things like that. So if you're looking for a 3-page chart and you are not interested in going through this entire slide deck, I also highly recommend NASFA's chart. Not surprisingly, they always do wonderful work. Okay. So the FAFSA exemptions, this is that first subtitle, pretty easy concept, but important to understand, and it's probably going to be or could be meaningful to some of your students on a go-forward basis. You'll recall the FAFSA Simplification Act, which you can also access by clicking on that link, removed the exemption for family farms and family-owned small businesses from the student aid index calculation, right? And that was effective with the 24-25 FAFSA. So in other words, folks, those family farms and family-owned small businesses were being included in the determination of the student aid index. So one of the things the OBBBA did was it reinstated this exemption. Not only that, but it also adds family-owned commercial fishing businesses, which is, here we have in parens, a commercial fishing business and related expenses owned and controlled by the family. So importantly, these types of assets are going to be excluded on a go-forward basis, at least for the foreseeable future, when that student aid index calculation is done. This takes effect on July 1st, 2026, and applies starting with the 26-27 award year. So that was the whole first subtitle. You nailed it. Wonderful job. It gets a little more complicated, but it always feels good to take something off the list. So now let's talk about loan limits. This is subtitle B. Okay, just by way of preview, and we're going to get into each one of these, but conceptually, there's sort of 4 big ideas here. One is the termination of Grad Plus loans. Then you've got new annual and new aggregate limits for graduate and professional loans. We have new annual and aggregate limits for Parent Plus loans, and consolidation loans are sort of worked in here. And then new lifetime maximum aggregate loan limits for all students. So for all loans, we have one big new lifetime maximum aggregate loan limit. Okay. So let's break these down. On the Grad Plus loan front, just to be clear, you've probably heard about this, but the Grad Plus loan program has been terminated. So for any period of instruction beginning on or after July 1, 2026, which is when a lot, not all, but when many of these ideas take effect, for any period of instruction beginning on or after July 1, 2026, graduate and professional students will no longer be eligible to receive a federal direct plus loan unless they qualify for what I'm calling the interim exception. And I'm going to get to the interim exception at the end of this. We're going to go through 3 or 4 things because this same concept, this interim exception, applies to lots of these new ideas. So rather than going through it every single time, just to be clear, I'm going to save it and go through it here at the end. But to be very clear, it does impact the new termination of the graduate plus loan program. We've had some schools we've seen who have talked about moving starts back, for example, before July 1 of 2026 to try to have folks start their programs prior to that date. I think a lot of institutions are thinking creatively about their opportunities here. We also, as you would probably expect, we expect to see the private student loan market work to fill this gap. I mean, our experience is graduate students are the type of student that lenders prefer to lend to because historically their repayment rates are a little bit better, notwithstanding the fact that they have larger debt loads, they tend to repay at a higher rate. And we also know institutions are thinking about other options, whether that be repricing or restructuring, that may mitigate the impact of the termination of this program. Let's talk about graduate and professional annual loan limits first. There's a lot of limits here, so I'm trying to stress on this page, we're talking about graduate and professional programs, annual loan limits. And there is a distinction being drawn by Congress between graduate programs and professional programs. So here for a graduate student, and again, this begins on July 1, 2026, subject to the interim exception that I'll get to in a minute, right? But for graduate and professional students beginning on or after July 1, 2026, the annual loan limit going forward is $20,500. For professional students, $50,000. So you can see there's a higher annual loan limit for professional students. And then we have a slightly more complicated framework for determining graduate and professional aggregate loan limits. Again, this is effective for students, graduate and professional students beginning July 1, 2026 or thereafter. And again, we've got the interim exception, right? So very important to keep in mind. But let's just walk through these quickly. So you sort of have four categories. You have a graduate student who is not and has never been a professional student and is borrowing for a program that awards a graduate credential upon completion, and the aggregate limit's $100,000. For a graduate student who is or has been a professional student, and they are borrowing and is borrowing for a program that awards a graduate credential, it's $200,000 minus any amounts borrowed for a program that awards a professional degree upon completion. For a professional student who is not and has not been a graduate student and is borrowing for a program that awards a professional degree upon completion, $200,000, nearly double, right? And then for a professional student who is or has been a graduate student at some point, but nonetheless is borrowing for a program that awards a professional degree, it's $200,000 minus any amounts borrowed for that program that led to the graduate credential. So you got to do a little bit of math, right, to figure out what their aggregate loan limit would be in these different buckets. Now, and I apologize, it looks like on my screen, maybe the chart is being squished together a little bit. I think you'll find on the PDF it's okay. But one of the obvious issues here, or not issues, but, things that we think institutions are going to be thinking very, very hard about and very quickly about is this distinction between professional degree and graduate degree. And, there are definitions. So in the act itself, Congress specifically directs institutions, they have a definition of graduate degree, which essentially says it's a graduate level degree and not a professional degree. And then it's got a definition of professional degree that points you to the current regulatory definition of professional degree. And it defines a professional degree as follows: a degree that signifies both completion of the academic requirements for beginning practice in a given profession and a level of professional skill beyond that normally required for a bachelor's degree. Professional licensure is also generally required. And then it gives you an illustrative but not exhaustive list of professional degrees, most of which are doctoral level degrees, but not all. You look at the end and you've got the theology degrees. Confusingly, you've also got iPads and NCES out there that uses a system that's similar to this, but not identical, and has been changed and was changed subsequent to this definition being entered into the regulations back in 2007. So we anticipate, previously this distinction between professional degree and graduate degree really wasn't that significant for most institutions. And it would not surprise us that many, without terrible amounts of thought, I don't mean to suggest folks were being flipped, but it wasn't that significant, right? You sort of thought about it and you designated it as one or the other, maybe reported it as such. We anticipate that many institutions at this point are going to be going back and reevaluating whether they think programs fit in one or the other of these buckets. I'll also note we think that's totally appropriate, right? I mean, you have an obligation as an institution to administer the financial aid programs to the best of your ability with accuracy, right, and precision. And so, going back and kicking the tires and making sure that you believe all these programs are properly categorized isn't at any point in time would be an appropriate exercise. The challenge is going to be you don't have a perfectly clear decision-making rubric. We've been working with clients to try to develop, that type of rubric so they can be thoughtful about if they do think they want to reclassify a program, how they might do that. We've been looking at, the Gainful Employment Financial Value Transparency Framework, the 2022 data set that the department put out, which would have labeled all your programs in that spreadsheet one way or another, but consistent with the NCES system, not necessarily with this guidance. So there are a lot of data points to take into account here. I'll just say for our part, I think we believe this is an appropriate exercise and you should be thoughtful as you move forward. And if you are going to reclassify a program, I would definitely document that, right, in your decision-making process, because if you were for some reason called upon to defend it, you would want to be prepared to do that. Again, we strongly suggest if you're going to go through the exercise, just be thoughtful about it and maybe consider working with counsel. And we believe trade associations and institutions alike are pressing the department right now for clarity, and that this also will be one of the issues addressed in the upcoming rulemaking. But it is interesting how this shift in sort of the construct for loan limits around graduate and professional degrees has made this determination so important. Let's talk about Parent Plus loan limits for a second. So there are changes both to the annual and aggregate limits. The annual limits for a Parent Plus loan beginning July 1, 2026, that total maximum annual amount per dependent would be $20,000. I do want to highlight too, that's all parents combined, right? So, you know, if mom and dad independently took out Parent Plus loans, this would still be the aggregate. It would depend on like that dependent, right? So it's the total amount for that dependent. Similarly, the aggregate limit is now will be $65,000 after July 1, 2026. Once again, for all parents combined. And just one other thing, you'll notice the double asterisk here after the 65,000. You know, there were 2 points we made. One is that, as with all these loan limits, this is subject to the interim exception, which I'm going to get to in a second. But also specifically on that 65,000 mark, we wanted to note that this is without regard to amounts repaid, forgiven, canceled, or otherwise discharged on any such loan. Okay, lifetime loan limits for all students. So there's now a lifetime aggregate limit for direct loans beginning on or after July 1, 2026. And it's for all students. And here I've got, again, the double asterisk, and you'll see what I mean by that is this limit does not include amounts borrowed by an individual on behalf of their own dependent. And what do we mean by that? So the idea is I've got an aggregate loan limit for me for when I'm in school trying to fund my education. And then there are the limits that would apply if I'm borrowing money for my child's education. And the point that they're making is you don't conflate those two, right? You've got the limits that apply to you for your education, and then you've got the limits that apply to borrowing you may do on behalf of a dependent, or that dependent may do on behalf of himself, right? That's the idea. The total maximum aggregate is $257,500. So in the future, when you hear stories about someone who got an associate degree and took out $600,000 in loans, you can say that can't be true because there is a lifetime aggregate limit for direct loans, at least after July 1, 2026, subject to the creativity of students. Okay, let's talk about the interim exception. I've mentioned this several times. So all of these loan limits in every case are subject to this interim exception idea. And this is your grandfather or legacy provision, right? So the idea is the new loan terminations. So this is also the termination of the Grad Plus loan program. The new loan terminations and limitations will not apply during what's called the expected time to credential for any student who, as of June 30, 2026, is enrolled in and has already received a direct loan for a program. Now, I just want to one note here. I've had a couple of institutions reach out to me and they said, oh, we're going to back up our start, right? So it's historically, you know, we start students maybe shortly after July 1 or in August, and instead we're going to have a start in June so that we can take advantage of the interim exception for these students, or they can take advantage of the interim section. I just want to highlight it. Not only do they have to have started as of June 30, 2026, and be enrolled at least, but they also have to receive the direct loan as of that point too. So just keep in mind, if you're exploring that strategy, it's not just a matter of getting them enrolled and potentially started. I guess there's some question as to whether they have to have actually started the term versus just enrolled, but also there's this loan concept that has to be satisfied as well. Okay. The other thing is just digging a little deeper into this notion of expected time to credential. It's actually the lesser of two concepts. So it's the lesser of 3 academic years, or the amount of time still required for the student to complete his or her program at the time that determination is made. So it can never be more than 3 years, but my expectation is in many cases it will be less than 3 years, because you're going to have a lot of students who, and this is under sort of a normal time concept that's also in the law, I didn't cover it here, but that's the idea. You know, you're going to have a lot of students who under normal time or normal progress would be able to complete their program within a year or 2 years. So that's actually going to be the expected time to credential. But for all of those students who satisfy these, and institutions are going to have to make this determination, by the way, of expected time to credential. But for all those students out there who would satisfy these, they're not subject to the loan terminations and limitations, right? They could take advantage of the interim exception. Two or three other really interesting ideas in this category that have come along, some that may be quite welcome by institutions. One is institutional authority to limit loans. I mean, I've had many conversations with institutions over the years that have been frustrated, often with regard to a single program, just because of the nature of that program, the students it attracts, and their ability to borrow. There is a sense that many students are borrowing more than they need to, and the institution doesn't have any ability to limit that borrowing. In fact, they would characterize that as overborrowing in many cases, right? Well, now Congress has given institutions a tool to potentially do that, notwithstanding the annual loan limits established by Congress. Beginning on July 1, 2026, institutions may limit the total amount of direct loans made for a program of study for an academic year that a student may borrow, or that a parent may borrow on behalf of the student, provided the limits are applied consistently to all students enrolled in the program. And I think that's going to be the tricky part, because sometimes within a program, you may have a program that brings in a lot of veteran students, and the way they get packaged, their GI benefits are sufficient to cover, and some of them often may be borrowing or taking out loans, and you may want to say, for this group, you guys really don't need that loan, those additional loans, you're just creating more debt, and it's not a good idea. But you wouldn't be able to just create a limit just for the veteran students, right? I mean, it has to be applied consistently to everyone in that program. Still, you may have some programs where you can say, nobody in this program needs to borrow more than X. Even taking into account cost of living, all those kinds of things. Or we as an institution can match, or we can provide whatever more may be needed, right? Given our system and the way we package and institutional awards made available. So we're going to take advantage of this to try to limit the amount of debt that students are taking on. Could be a very positive tool. I would watch for the more guidance. Rulemaking is going to talk about this. You want to make sure you implement it correctly. Proration for less than full-time enrollment, also a really big deal, right? So in any case in which a student is enrolled in a program on a less than full-time basis during any academic year, the amount of a loan that the student can borrow for the academic year or its equivalent, quote, shall be reduced in direct proportion to the degree to which that student is not so enrolled on a full-time basis, rounded to the nearest whole percentage point. So in other words, trying to boil this down, make it a little easier to digest, as NASFA would have on their chart, institutions have to prorate annual loan amounts in proportion to the percent of full-time status of students enrolled. My expectation is there will be not a few institutions and financial aid folks who feel like this is also a positive development, right? Potentially. I would again keep a lookout for information from the department. And actually, to that point, I will go ahead and take this opportunity to remind you guys that on July 18th, the department released a Dear Colleague letter. You can get to it by clicking on that link, observing that while many of the changes that we've talked about and will talk about take effect on July 1, 2026, there are some that actually became effective upon enactment, in other words, on July 4th of this year. So the DCL tries to address specific, like the whole purpose of this Dear Colleague is to sort of call out those provisions that were essentially effective immediately when the law, when the legislation was signed into law. And then the department promises there's going to be more guidance on a go-forward basis. That the one of those provisions, the one that falls in this loan limits category, right, is the one dealing with proration. So the department observes in the Dear Colleague letter, if you hadn't seen this, it says the department is currently developing the schedule of reductions that will be required by OB3 and will submit it for public comment later this year. Once public comments are received and reviewed, the revised schedule of reductions will be issued by the secretary and used to determine the reduction in the annual loan limits for students who are enrolled on a less than full-time basis, right? So my advice would be, check with counsel, right? But it does not appear to me there's an expectation that institutions will begin prorating right away, right? I think the expectation is, and also the way the law, that there's even language in the statute or in the act that suggests that it's going to be pursuant to a schedule created by the secretary. So my advice would be, again, check with your own counsel, but my advice would be you need to wait till the schedule comes out. Don't start prorating things right now. The department's going to give you guidance, and it's going to actually say, based on current loan limits and loan amounts, et cetera, if folks are half-time, if folks are three-quarters time, et cetera, this is how you should be prorating. All right, this brings us to our next subtitle, Subtitle C, which is loan repayment. If you are like me and you're an attorney and not a financial aid professional, the existing repayment plan landscape is pretty confusing stuff. So before we get into where we're going, I thought I would take just a minute to try my best to lay out for you where things are right now, and hopefully at least graphically in a way that will make it a little easier to understand. We'll see if I've been successful or not. I would ignore, for the most part, the descriptions of each one of these plans. You probably don't need to get into that. You can always go back and look or read more somewhere else if you'd like. Really, what I want to just impress upon you right now is we have sort of two big buckets, right? We've got fixed repayment plans and we've got income-driven repayment plans. And we have a lot of terms that sound pretty close, which makes this confusing. But just keep in mind the two big buckets are fixed repayment plans and income-driven repayment plans, IDR plans, right? And one of the things I just want to highlight is all the income-driven repayment plans feature, and you'll see I put it in parens here, it's small, but it's there, feature loan forgiveness following enough qualifying payments. That's part of the idea, right? So if you look in the fixed repayment plan bucket, you have three concepts. We've got the good old-fashioned standard repayment plan, a graduated repayment plan, which is still fixed, but sort of over time amounts, payments start low and then increase, graduated. And then an extended repayment plan, which is what it sounds like. You just get more time to do it. Okay. And then within the income-driven repayment plan bucket, we have, in theory, four concepts. The first is income-based repayment, or an IBR plan. The second is income contingent repayment, an ICR plan. We've got pay-as-you-earn, the PAYE repayment plan, and then repay, or the SAVE plan down at the bottom, which has been tied up in litigation. But the idea here, again, is that there are four items there. In the income-driven repayment plan bucket, the first two are statutory creations. So Congress created those. Pay-as-you-earn and repay/save are regulatory creations from the Biden administration. Okay, so three fixed repayment plans, and then we got four income-driven repayment plans. One of the things Congress wanted to do here was just simplify all of this. And I think there are folks on both sides of the aisle and throughout higher ed who probably felt like there was some merit to that. Things were getting a little complicated, I think, my opinion at least. So they're trying to simplify this repayment plan landscape a little bit. OB3 aims to do that by essentially establishing two plans on a go-forward basis, right? And the idea is all borrowers who receive loans that are made after July 1, 2026 will have to go into one of these two. We've got a new standard repayment plan, and then what we'll call the repayment, or what they call, Congress calls, the repayment assistance plan, or the RAP. And I just have to say, as a dad and a middle-aged guy, it was really hard for me to avoid coming up with lots of really bad jokes around the RAP, but I have done it for your benefit. So I hope somewhere I will get bonus points for that. Okay, so let's first talk about the new standard repayment plan. Has four fixed terms of 10, 15, 20, or 25 years for repayment, right? So it is standard, but there's variation within it. The repayment period is based on the amount borrowed or the total outstanding balance as follows. So for a borrower with total outstanding principal of less than $25,000, 10 years. For a borrower with a total outstanding principal of between 25 grand and 50 grand, you've got 15 years. If you're between 50 and 100 grand, you've got 20 years. And if you have over $100,000, it's 25 years or more. And again, at least on my screen, these charts are getting a little squished together, but I do believe the PDF and the resources, they should be laid out correctly without any crunching. So the new repayment assistance plan, and the idea here is you've got sort of the fixed repayment, the new standard, right? And then over here, you've got something that takes into account sort of income. So here are the features. The monthly payment is supposed to be 1 to 10% of income based on AGI, adjusted gross income, with a $10 minimum payment. The repayment period is 30 years. There's no cap on monthly payments, even if it's higher than the monthly payment under the standard repayment plan. Borrowers can receive $50 off their monthly payment per dependent. This is a little complicated to wrap the brain around. If a borrower makes an on-time payment that reduces his or her principal by less than $50, the department will make a payment to the principal up to the amount paid minus what was applied to the principal, or $50, whichever is less. I think the most important point there is that the department is making a payment, right? And if married filing separately, the spouse's AGI and number of dependents are not included in the payment calculation. This is a pretty good sketch. There are a couple other little components that go along with the RAP, and you can get the whole thing if you want to go look at the red line. It's sort of out, it's in kind of is in one place, so you can sort of read about it all at once for the most part. Or again, NASFA's got great coverage of this and has included this in their chart as well. Let's talk about some repayment plan principles when we talk about sort of the implementation of this transition from our 7 current plans to our 2 plans of the future. But first, before we talk about transitioning folks who already have loans, let's just talk about folks who are getting loans for the first time on or after July 1, 2026. So for those borrowers, they're going to have to choose, as previously stated, between one of these two, the new standard repayment plan or the RAP. If a borrower who takes out federal loans for the first time on or after July 1, 2026 does not select a plan, then they'll be automatically assigned to the new standard repayment plan. But unless you're talking about some type of loan that would otherwise be ineligible, borrowers can switch back and forth. So even if they're assigned to the standard repayment plan, they would have the opportunity to get into the RAP. They'll just be automatically started in the standard repayment plan. With limited exception, borrowers must pay all loans under the same repayment plan. And this is a really important point because if you are a borrower with loans made before July 1, 2026, and then you take out additional loans after July 1, 2026, in a sense, those loans you take out after July 1, 2026 are going to pull you into one of the 2 new plans, right? Because the notion is loans after July 1, 2026 have to be in one of the 2 new plans, and all a borrower's loans have to be in the same place, right? So if you've got someone who has legacy pre-July 1, 2026 loans, and they borrow new loans after July 1, 2026, basically everything's going to get pulled into one of those 2 plans. What about borrowers who've got loans, they've taken them out today, and they're in one of those 7, and they have no intent, and they never take out any new loans after July 1, 2026? Okay, so for folks in this bucket, borrowers with no new loans made on or after July 1, 2026, including consolidation and Parent Plus, are eligible to enroll in the current standard, graduated, or extended plan. So that's all the current fixed, right? Or IBR plans, or the new RAP. So they got a lot of options, right? They got a lot of options. But there's a handful that are not options on a go-forward basis, and that's income contingent repayment, pay, and SAFE. So that's the one statutory concept, income contingent repayment, and then also pay and repay or save, which were the 2 regulatory concepts created by the Biden administration. So prior to July 1, 2028, anyone who's in this category can switch between enter or remain on any of these options under the first bullet, right? So on any of the existing IDR plans, but all of these folks, sorry, let me restate that because that was not totally correct. Let me restate that. So prior to July 1, 2028, everyone who's in this bucket can switch between enter or remain on any of the existing IDR plans, I should say. But all of them have to be on one of the approved legacy plans in that first bullet by July 1, 2028. So between now and July 1, 2028, they can move around. But as of July 1, 2028, everyone's going to be on one of the things, I'll call it the approved legacy plans in that first bullet. And what that means is if you are currently on ICR pay or save, which are not approved legacy plans, you're going to have to get off those plans by July 1, 2028. So everyone who's currently on income contingent repayment, pay or save is going to have to make their way into standard, graduated, extended, IBR, or the new RAP, right? It's a lot to keep track of, but you've got this slide you can come back to. Okay, new consolidation of Parent Plus loans. Consolidation loans made on or after July 1, 2026 are eligible for either the new standard repayment plan or the new RAP. However, Parent Plus loans made on or after July 1, 2026 have to be repaid under the new standard repayment plans. The RAP's not available. A borrower with Parent Plus loans made before July 1, 2026 who takes out additional Parent Plus loans on or after July 1, 2026, again, is going to get sucked in, right, per that principle we talked about previously, and everything will have to be put under the new standard repayment plan. So you sort of lose. It's like I'm trying to build a new shed I'm trying to renovate a shed in my backyard. And if I do too much in the way of renovations, according to the city, it's considered a new structure. And now I have to comply with current code. And I'm not grandfathered in to the pre-1955 codes. It's the same concept. Okay. Additional loan repayment revisions that are worth note here. These, by the way, become effective July 1, 2027. So all that other stuff, we were sort of revolving around July 1, 2026 and a little July 1, 2028. Now we've got a different marker. Economic hardship and unemployment deferments are being removed. Borrowers can rehabilitate a defaulted loan twice. Currently, only one rehabilitation is allowed. That's probably positive, as we're all facing increased core default rates and sort of default concepts. The minimum rehab payment for direct loans becomes $10, and loans made on or after July 1, 2027 become eligible for forbearance for up to 9 months in any 2-year period. And then I mentioned earlier that Dear Colleague letter. There were a couple of ideas in and around the loan repayment restructuring that also became effective immediately. So we're included in that Dear Colleague letter. OB3 eliminates the requirement that borrowers have a partial financial hardship to qualify for enrollment in an income-based repayment plan, or an IBR plan. And the department observed in its DCL that change was one of the ones that was effective immediately as of July 4th. So the agency, quote, is currently working with its student loan servicers to remove the partial financial hardship eligibility requirement from the IBR enrollment process. More on that to come, I'm sure. Also in its DCL, the department observed that under the new legislation, borrowers with a consolidation loan that repaid a Parent Plus loan to enroll in an IBR plan, or they're allowed under OB3, to use a consolidation loan to repay Parent Plus loans to enroll in an IBR plan. The Secretary, again, will provide additional information to its federal loan servicers and update its studentaid.gov website. And again, I'm sure more guidance will be forthcoming. But just wanted to call out that one was also technically effective right away, and the department is scrambling or moving quickly to try to put that into place. All right, we're marching through the subtitles. Pell grants. Pell funding for the shortfall. So first of all, this was really important, as we've discussed on prior webinars and conversations, and I'm sure many of you are aware, Pell grants are projected to run a pretty significant deficit in the future, up to $98 billion by 2035. We still don't have a permanent fix to that long-term shortfall, but this legislation, OB3, appropriated an additional $10 billion and change for fiscal year 2026 to try to address that projected Pell shortfall in the near term. So that's great, right? So we've got additional funding. The other big innovation was the introduction of workforce Pell grants, which is sort of the name that's been given to the short-term Pell concept here. So for the award year beginning on July 1, 2026, next year, the department will begin awarding workforce Pell grants. At least that's what they're supposed to do under the legislation. To be eligible, students must meet general Pell eligibility requirements, be enrolled or accepted for enrollment in an eligible workforce program. By the way, the reason I seemed a little reticent on that prior bullet, because I want to get into this definition of eligible workforce program. Not be enrolled or accepted for enrollment in a program that leads to a graduate credential, right? And not have obtained a graduate credential. The terms and conditions for awarding workforce Pell grants are generally the same as for Pell grants, except that non-credit remedial English language instruction study abroad courses are not eligible. Also, a student may receive a workforce Pell grant in an amount that's prorated based on the length of the program, notwithstanding that the amount is less than the minimum Pell grant because the workforce program is less than an academic year. Also, unaccredited institutions, it's not on the slide, but unaccredited institutions are not included, as this is not an opportunity for them. Right. A student can't simultaneously receive a workforce Pell grant and a regular Pell grant, and any period of study covered by a workforce Pell grant is included in determining the student's overall Pell eligibility. But here is where my concern comes in. So what is this concept of eligible workforce program? I've had institutions reach out to me and others in our practice already saying, hey, we think we're eligible, we're good to go. You know, how do we start getting these Pell grants? So per the legislation, an eligible workforce program, to become one, a program is eligible if it's a program of at least 150 clock hours of instruction, but less than 600 clock hours of instruction, or an equivalent number of credit hours, offered by an eligible institution during a minimum of 8 weeks, but not less than 15 weeks. Okay, that's easy. Most of you can instantly identify if you've got a program in that bucket, or you may have one that you're ready to roll out that would fit in that bucket. Is not offered as a correspondence course. Also easy. Okay. But it's these last two bullets that are a little concerning to me. In addition, the governor of the state, after consultation with the state board, has to determine that the program meets certain additional requirements that are specified in the statute. And then after that's happened, the department has to determine that the program meets additional specified requirements. Okay, so what are these additional specified requirements? And I know this is a lot of text on your screen. I was telling my wife earlier today, I try to avoid this. Yes, it is true that my wife and I occasionally talk about my presentations. That is a sad fact of life for her. But I was telling her I was doing this on purpose because I wanted to highlight how complex this is. Look at this. It says the governor, in consultation with the state board, has to determine that your program provides an education aligned with the requirements of high skill, high wage, or in-demand industry sectors or occupations, and meets the hiring requirements of potential employers in the sectors or occupations, and either leads to a recognized post-secondary credential that's stackable and portable across more than one employer, or prepare students for employment in an occupation for which there is only one recognized post-secondary credential and provides that credential upon completion, and prepare students to pursue one or more certificate or degree programs at one or more institutions of higher education, right, including by ensuring that the student upon completion of the program and enrollment in the related certificate or degree program will receive academic credit for the workforce Pell Grant program that will be accepted toward meeting the certificate or degree program requirements and the acceptability of the credit toward meeting the certificate or degree program requirements. So here's my question to you. How quickly do you think that your governors and your state education boards are going to be able to develop the machinery needed to render these decisions? Okay, so that's the first question. Then, after your governor has signed off on this, the department has to determine that the program has been offered by the institution for not less than 1 year prior to the date on which the department makes its determination. And for each award year, the program has a verified completion rate of at least 75% within 150% of the normal time for completion. I don't know about you, but I have no idea how this completion rate is being calculated, where the data is coming from. I don't know if that's through the financial value transparency data reporting that's occurring, when the department's going to be able to make those calculations. Keep in mind, this is an agency that still has a direction from the White House to diminish itself as much as possible under the law. For each award year, the program has a verified job placement rate of at least 75 or 70%, measured 180 days after completion. And for each award year, the total amount of the published tuition and fees of the program for such year is an amount that does not exceed the value-added earnings of students who received federal financial aid and completed the program 3 years prior to the award year, as such earnings are determined by calculating the difference between the median earnings of students and 150% of the poverty line applicable to a single individual. So for those of you who have programs that you are ready to roll out as eligible workforce programs, and we're hoping to fund July 1, 2026, I hope that you are able to do that. But I just wanted to highlight, and this is all in the statute, by the way, right? The department can't waive this, or if they do, I mean, it's only within certain parameters. I think there's a lot of work that can be done in NEGREG. Maybe some of these can be waived so that they can implement in years 1 or 2 or 3. But clearly there is a lot that has to be done here for programs to even be certified as eligible workforce programs, right? And I just think we've got a lot to be seen. If you're really interested in this, by the way, which I'm assuming many are, one of the things I would do is start working with trade associations in the state and maybe at the national level to start reaching out to governors and state education agencies, et cetera, whatever you think would make sense, to try to talk to them about an awareness of this. Are they talking with each other? Are they building infrastructure that's going to be used to approve these programs rapidly so students aren't being disadvantaged? But all this is to say, I think there's a lot of work that still has to be done to get there. At least that is my impression. Okay, foreign income and Pell eligibility. Under current law, financial aid staff must individually determine if adding exempted foreign income to a student's AGI, this is currently a maximum Pell Grant. So OB3 revises the law to require that for Pell Grant determinations made on or after July 1st, 2026, foreign income has to be included in the AGI used to calculate Pell Grant eligibility. The SAI threshold for Pell eligibility. So effective July 1, 2026, a student is no longer eligible for a Pell Grant for any academic year in which the student's SAI equals or exceeds twice the amount of the total maximum Pell Grant for that academic year. So your financial aid folks will be paying very close attention to these changes to make sure they're packaging and making determinations correctly. And here's another one, non-federal aid threshold and Pell eligibility. So effective July 1, 2026, a student's no longer eligible for a Pell Grant for, quote, any period for which the student receives grant aid from non-federal sources, including states, institutions of higher education, or private sources in an amount that equals or exceeds the student's cost of attendance for such period. Shout out to my colleague, Howard Wesley. He and I were talking about, how this is going to complicate packaging, because so many of you have processes that rely first on a determination of whether a student is eligible for or receiving a Pell Grant. And then this determination regarding the amount of institutional aid is made. There are also, we know, employer programs and other scholarship, external scholarship programs, where embedded into their guidelines first is a determination as to whether or not a student is eligible for or has received a Pell Grant. And what this would appear to do is require all of that to sort of be flip-flopped, right? Because what they're saying is, if first there needs to be a determination as to whether or not there is sufficient aid to cover the student's education before a Pell Grant has been received. So I don't know. I think institutions are going to have to be thoughtful about this. I think this is another one that's going to get a lot of conversation. I'm sure NASFA is thinking a lot about this, and all the other SFAs around the country, because it's going to be difficult to understand how to move forward, I think, without some guidance from the department and some determinations being made. Accountability. So if you are signed up for the Thursday webinar, what I'm going to do is, the promise here was soup to nuts. I'm going to lay out for you the accountability framework with not a lot of extra commentary. If you are interested in extra commentary, and there will be quite a bit from me, please tune in on Thursday. And what I will be doing on Thursday is the first 15 or 20 minutes will again just lay out exactly what the legislation sort of says is supposed to happen. And then the last, hour or so, I'm going to spend really getting into the weeds. In fact, I think that's the title of Thursday's presentation, Into the Weeds. But for today, we're going to at least walk through the accountability framework, because I want to make sure if you can't attend on Thursday, or you're just not interested in the weeds, that you at least get some exposure to it. So this is the thing that was called by Congress and in the press as the do no harm framework, their new accountability framework, right? I'm just going to call it the D&H. So the D&H accountability framework is located in Section 454 of the Higher Education Act, which governs the content of program participation agreements. And the reason I'm pointing this out, so just to be clear, what I'm saying is OB3, right? OB3, and we talked about right now, we're in that in subtitle here. I'll go back. So all of this is in subtitle E, and that is one of the red lines you can access. But what subtitle E of the OB3 does, the One Big Beautiful Bill Act does, is it says make changes to Section 454 of the Higher Education Act, right? So that's the section of the Higher Education Act that's being altered, and it's the section that governs the content of program participation agreements. I bring that up to say, at least at present, what institutions are being asked to do is to certify compliance with certain ideas, and those ideas are all embedded in the program participation agreement. So that's where they'll be. Also at present, it's important to note that this framework is in addition to the existing financial value, transparency, and gainful employment rule that is already out there, that is subject to legal challenge, but that this administration is defending. So the Biden administration created this rule. This administration is presently defending the rule, and litigation has said it's going to move forward defending it. At the same time, they now have this directive from Congress. So they've already announced a rulemaking. We'll get to that later. And they are going to try to reconcile all of these things. But for the moment, I just want to make clear that Congress in the OB3 did not say, we want you to change the financial value, transparency, and gainful employment framework, and here's how. They didn't say anything about that framework. They just said, here's a new thing, and threw it out, even though it is clearly very similar to certain components of the financial value, transparency, and gainful employment rule. Okay, PPAs will be revised to require institutions to certify that beginning July 1, 2026, they will comply with this do no harm, or D&H framework. The accountability framework, the new accountability framework, the D&H accountability framework, only applies to educational programs that award an undergraduate degree, graduate or professional degree, or graduate certificate. Let me say that again. Financial value, transparency, and gainful employment is still out there. It is a regulation that is on the books, and it applies to all Title IV institutions, or all Title IV programs offered at Title IV institutions, right? The new thing that we're talking about today, the do no harm accountability framework, only applies to educational programs that award an undergraduate degree, a graduate or professional degree, or a graduate certificate. Right? So that's really important to keep in mind. As such, it appears that the framework does not extend, the new one, the D&H framework in OB3, does not extend to undergraduate diplomas and certificates and post-baccalaureate certificates. Congress did not actually detail the universe of program types in the OB3, but if you look at the financial value transparency and gainful employment rule, actually it's a little helpful because they have 8 different categories of programs. This is slightly different from what you would see in like iPads or with NCES, but we just for illustrative purposes, everything in orange we think would be covered, right? But post-baccalaureate certificates and undergraduate certificates or diplomas, so non-undergraduate, non-degree certificates or diplomas, and post-baccalaureate non-degree certificates, we think would be excluded from coverage by the DNH. Okay, here's the basic premise. The department is going to subject every covered program, that's the ones I was just talking about, to a median earnings test. If a covered program fails the median earnings test, it'll be deemed a low earning outcome program. So to be clear, this is not a debt to earnings test. Nobody's looking at how much you charge your students or what your program costs. They're just looking at earnings. That's it. If the covered program fails to meet that earnings test, it will be deemed a low earning outcome program. If a covered program fails once during the 3 years immediately preceding the date the department makes its determination, the institution will be required to issue a warning to students in that program. And this is the most important point. And boy, if you've been following the OB3 and you've been reading all the summaries, that have come out, et cetera, super important. And all the loan limits and Pell Grant thing we were talking about, super important. But please hear me, because this is serious business. If a covered program fails twice during the 3 years immediately preceding the date of determination, the program will lose its access to direct loans. So what we are saying is the Department of Education is going to run a test on every degree program in the United States. And if those degree programs fail this earnings test 2 out of 3 years, students in those programs will no longer have access to direct loans. Pretty important concept. For covered programs granting a baccalaureate or lesser degree, so I'm talking about your bachelor's degrees and your associate's degrees, the median earnings of working completers, that's people who completed your program, are out in the world and working, who graduated 3 to 4 years before the determination year, are going to be compared to the median earnings of working adults aged 25 to 34 who only have a high school diploma or its recognized equivalent. Now, just want to highlight, and I'm going to get into this on Thursday. I promise I'm not going to get into all of the detail today. But just by way of example, right? Keep in mind, so we're sampling your graduates 3 or 4 years after they graduated from your program, okay? The other number that the department's going to be using is going to include people who may have graduated high school 10 years before the date they're being sampled. So they may have been successfully out in the workforce earning, at 34, actually, you've been out in the workforce for maybe 16 years. Right? So there are a lot of apples to oranges issues here that I'm going to talk about on Thursday. And I highlight that now just to say, because I can see some people looking at this and saying, oh, well, all of our folks are graduating or making more than folks who didn't get any college at all and just graduated from high school, right? The other thing to remember is your folks, if you are in a rural location, may largely work in your rural location. These 25 to 34-year-olds, best case scenario, are across your entire state. So if I'm in, Southern California, if I'm down in El Centro, and that's where I'm located, and my graduates are largely working in that area, their earnings are being compared to 25 to 34-year-olds, albeit with no college education, but who may be working in San Francisco and Los Angeles and elsewhere. So there are a number of serious apples to oranges issues here. And I just want folks to be aware of that so they don't think this is an easy slam dunk. Even more disconcerting to me is the median earnings test that will be applied to covered programs that grant a graduate or professional degree. So in this case, here's the test. Median earnings of working completers who graduated 3 to 4 years before determination against median earnings of working adults aged 25 to 34 who have a bachelor's degree. So to be clear, now my master's in social work is being compared to someone with a bachelor's degree in accounting or engineering, right? Or any other number of bachelor degree programs, computer science, et cetera, right? And that could include people who graduated with bachelor's degrees in engineering who are working in San Francisco, right? Being compared to my master's of social work program in rural Southern California, right? So again, I would not assume that this is a slam dunk for every program. I think colleges and universities should be seriously looking at this and seriously engaged with their trade associations and others and being thoughtful about the rulemaking and other things that are forthcoming. I promise I will stop getting into the weeds. We'll talk more about this on Thursday. What is a working completer, by the way? I previewed this just a second ago. So working completers, this is your students who are working completers, are folks who completed the covered program during the academic year, that is 4 years before the year of determination, received any form of Title IV to fund their enrollment. So we're only talking about folks who got a Title IV loan or grant to fund their enrollment, are not enrolled in another institution of higher education, right? So if they're not earning anything, if they're in further education, they're excluded, and who are working. And by the way, this was at least a big improvement in the do no harm over the financial value transparency and gainful employment framework. It also has an earnings test, and that earnings test takes all of your graduates, whether they are working or not. So at least in the one that Congress created here, the do no harm, they're only looking at your graduates who are working. They may not be working in field or doing what you train them to do, but they have to at least be working. Okay, what's a working adult? This is the other side of the equation. A working adult is a working adult who, during the year of determination, is between 25 and 34, is not enrolled in an institution of higher education, and in the case of a determination made for an educational program that leads to a bachelor's or associate degree, has only a high school diploma or its recognized equivalent, or in the case of determination made for a graduate professional program, has only a baccalaureate degree. Okay. What about where's the earnings data coming from? So the statute doesn't clearly direct the department to obtain earnings data for your working completers from any specific source. It simply refers to the median earnings as determined by the secretary. You know, our expectation would be you're looking at the IRS or SSA. That's where the data has been gathered as part of prior gainful employment, financial transparency, value transparency frameworks. What about the earnings for those working adults? This is a really important point too, right? The department is not going to go out and do an earnings survey or pull earnings data for every individual in every state between 25 and 34. That they're just not going to create a new metric. So just as they did with financial value transparency and gainful employment, here Congress is essentially directing the department to use a data point that's out there and already exists. And it's one that's already determined by the Bureau of Census. So this is something they already generate on an annual basis. But how the median earnings will be calculated varies based on the program level. So for a baccalaureate or lesser degree program, again, your bachelor's and associate degrees, right? If that's the program that's being compared against, when you look on the working adult side, we're looking at the median earnings for those working adults, right? In the state in which the institution is located, okay? Unless fewer than 50% of the students enrolled in this institution reside in the state where the institution is located, in which case the median earnings will be based on the earnings for working adults across the United States. So now this is also a confusing way to say this, and it's different from the financial value transparency and gainful employment rule, because we're not talking about fewer than 50% of the graduates of the program still being inside the state or outside the state. It actually says fewer than 50% of the students enrolled in the institution across all programs reside in the state where the institution is located. Hard to understand why that's the relevant metric. Also, it seems to tie to residency and not location. So there are a number of things that are going to have to be worked out in NEGREG. But the idea here is if you are an institution that has a lot of students spread out all over the place, let's say you got a main campus and a bunch of additional locations, right, around the country, and more than 50% of your students are not at your main location. Now the number that you're competing against is not a state level number, it's a national number. Right. So again, take my example. I got a master's of social work, or in this case, an associate degree that I'm offering in South Central California in a rural area. And the earnings of my graduates are being compared to graduates nationally from 25 to 34. Okay. For a graduate or professional degree program, it's even more complex. The median earnings will be the lowest median earnings of working adults in the state in which the institution is located, working adults in the same field of study in the state in which the institution is located, and working adults in the same field of study across the entire United States. So they're calculating 3 different median earnings and taking the least, unless fewer than 50% of the students enrolled in the institution reside in the state where the institution is located, in which case the median earnings will be the lower median earnings of working adults across the entire United States or working adults in the same field of study as determined across the entire United States. So very complicated also for the department to execute here. I mean, you've got all these different median earnings you're going to have to calculate for every single, in every single case, and then you're picking the one that's the least of all of them. Okay, there's this small cohort protocol, which I won't even comment on other to say that it is very hard to understand what this is about. For any year for which the programmatic cohort is fewer than 30 individuals, so your cohort, 4-year program, your number of completers is fewer than 30, the department's going to attempt to aggregate additional years of programmatic data in order to achieve a cohort of at least 30 individuals. That part seems to track and be consistent with what we've seen in prior gainful employment financial value transparency rules. The notion is if you don't have at least 30 completers in that cohort we're looking at, we'll expand back a year or 2 years or maybe forward a year or two so we can get over 30. And the root concern here is a privacy concern. There's always been a feeling that if you got fewer than 30 completers, folks could potentially even identify individuals and how much they're making, that kind of thing. But here's the really confusing piece of this. And keep in mind, this is in statute. If following this effort, the cohort is still fewer than 30 individuals, the department will attempt to, quote, this is out of the legislation, aggregate additional cohort years of programmatic data for educational programs of equivalent length in order to achieve a cohort of at least 30 individuals. So what Congress seems to be directing the department to do is, if your master's program, master's in education program doesn't have at least 30 graduates, or, community colleges, there was a lot of concern historically, and that's where some of this may come from, that a lot of community college programs weren't being captured under gainful employment, including their non-degree programs under that framework, because they didn't have enough graduates. And the department just said, well, if we don't have enough graduates, we won't calculate it. What Congress is saying is, look, if you've got this one associate degree program that's a year, 18 months long, in HVAC, and it doesn't have enough graduates, doesn't have at least 30, we're just going to start roping in like your medical assistant graduates or legal assisting or culinary or any other potentially 18-month-long associate degree program so we can get to 30. So now we're talking about individuals who have been trained potentially to do completely different things, which seems to fly in the face of this whole framework, right? I mean, the whole idea here is we're trying to measure whether programs are successful or not, and now we're pulling in data for different programs. I'm really personally struggling to understand this idea. Okay, appeals process. Congress has specifically provided that a program shall not lose eligibility for direct loans unless the institution has had the opportunity to appeal the median earnings calculated for its working completers. So this is great. The current financial value transparency gainful employment rule has no appeals process. The Congress has directed the department, at least in the do no harm framework, to include an appeal concept. And I'm going to talk about this at length on Thursday, they haven't given many guidelines as around what that appeal process has to look like, which means the department has some flexibility potentially to be creative here. Regaining eligibility, important point. So Congress has directed the department to establish a process by which an institution that has a covered program that has lost access to direct loans can, after a period of not less than 2 years, apply to regain such eligibility. Putting this in another way, if your program fails 2 out of 3 years and loses direct loan access, you have lost it for 2 years. You can't get back in quickly, right? So you're out for at least a couple of years. Taking a deep breath. So again, you all that follow me or have watched other webinars that I do or just generally know me know that the accountability stuff is important to me, but hopefully it is evident that it should be pretty important to all of higher ed. I think the consequences potentially are quite meaningful. And I think there's a lot of work for the department to do and for this community to do at the table during negotiated rulemaking. Quickly, let's talk about regulatory relief. Again, that's subtitle F. Subtitle F, if you were to go to the legislation itself. So Section 85001A of OBBBA expressly states that the Biden administration's 2022 BDR rule is not in effect for loans that first originate before July 1, 2035. There were lawmakers that actually wanted to just strip it off the books. In other words, just pass legislation that said it's gone. But the Senate parliamentarian said you couldn't do that in the context of reconciliation, which recall is supposed to be about money and not sort of general broad-based legislating. While not formally repealed, the 2022 BDR rule can never be applied to loans first dispersed over the next decade, right? So even if the rule is still on the books in 2035, the way this is written, it can never be applied. Section 8501B also expressly states that the Trump administration's 2019 BDR rule is specifically restored and revived as it was in effect on the date it became effective, right? But here's a really important point I want to make for everybody, because I've seen some shorthand summaries and things sort of suggest that BDR is gone, and that's not true. Each time a new version of the bar defense rule has come along, at least up to the Biden administration's version. But when the Clinton administration created IS, and then the Obama version and the Trump 1 version, each time the way they did it was they added on to the existing regulatory framework. It didn't completely cancel out the prior rule. So while the 2019 BDR rule has been officially restored and revived, it still exists alongside the 94 and 2016 versions of the rule. Here's a little graphic to help you see what it looks like. So post OB3, the 94 rule still applies to loans dispersed first prior to July 1, 2017. The 2016 Obama era rule applies to loans dispersed on the first time on or after July 1, 17 and before July 1, 2020. The 2019 Trump 1 era rule applies to loans dispersed on or after July 1, 2020. And then that 2022 rule is still technically on the books and will apply to loans first originated on or after July 1, 2035. So if someone has suggested to you that there is no longer a bar defense rule, that is inaccurate. There is still quite a complex framework sitting on the books, and the department, folks can still file claims, and the department still has processes pursuant to which to adjudicate those claims, including, where applicable, the Obama administration's 2016 rule. As the graphic demonstrates, we already talked about this. So Congress expressly affirmed the existence of 2019, but 94 and 2016 exist alongside it. In a sort of similar vein, Section 8502A of OB3 expressly states that the Biden administration's 2022 changes to the closed school loan discharge rules are not in effect for loans that first originate before July 1, 2035. Okay, so similarly, though that rule's still on the books, but cannot ever be applied to a loan that originates before July 1 for the next 10 years, right? 2035. This is important because this included an automatic discharge feature. So the Biden administration's rule would have included a feature that said after a year, if a school closes or an additional location closes and a student has not either completed or gone somewhere else and enrolled in another Title IV program, the department would sweep their systems essentially, and their loans would be automatically discharged based on the closure of the institution, right? But so that's a big difference, because that's not on the books. What that means is students have to apply to get their closed school loans discharged. But it's really important to understand that there is still a closed school loan discharge rule on the books, right? So nothing about this legislation, OB3, eliminated closed school loan discharge from the regulations. It just said that the changes the Biden administration wanted to make in 2022 are not effective until 2035. All right. One slide. This is not my bailiwick, but I did put this together just to be true to our soup to nuts theme here. There is a new endowment tax framework. It's a tiered framework based on basically the size of the endowment relative to how many students the institution has. And you can see the 3 tiers here, the student count threshold. So it applies only to private universities with at least 3,000 tuition paying students, which is a rise from the previous 500 student threshold, which I think is going to be welcomed by some smaller schools. But it now includes student loan interests and royalties from federally funded R&D and IP. Importantly, it no longer excludes international students from the per student calculation. So that student count threshold was raised to 3,000, but you're now including international students, and it applies to tax years beginning January 1, 2026. I want to talk just briefly now at the end here about NEGREG, and I think we will have a little time for questions. So on July 25th, just a couple of weeks back, the department announced its intent to establish two negotiated rulemaking committees to implement changes made by OB3 and other administration priorities. The way to read that is this administration was already thinking about what it wanted to do and coming up with its NEGREG schedule, and then this legislation came along. So now they're trying to integrate everything Congress told them to do into their agenda that they were already putting together, right, and formulate a NEGREG schedule going forward. In advance of the negotiated rulemaking, the department will accept advice and recommendations on the implementation of the changes. That's through August 25th. So you have to nominate negotiators by August 25th. Also, if you just want to submit ideas to the department, like this is the stuff we think you should change within the scope of this negotiated rulemaking, you have an opportunity to do that as well. Suggestions can be filed through the federal e-rulemaking portal. By the way, that docket number has since been updated. There should be an OPE in there, so I apologize. But what you can do is go to the announcement, the NEGREG announcement, and find your way there. Let's see. There are two committees. The first committee is the Reimagining and Improving Student Education, or RISE committee, which is going to, generally speaking, consider changes to the federal student loan programs. I'll give you a little more detail in a minute on what they're going to do. Again, nominations can be made by August 25th. You can just do those through email. Please note there are 2 committees. I'll talk about the second one in a second. The emails are different for each committee. So if you want to nominate somebody for the RISE committee, you should send it to nominations federal student loans at ed.gov, right? And you'll see for the AHEAD committee that I'm going to get to next, it's a different email address. I just don't want you to confuse those. Negotiators are going to meet for 2 sessions, which is interesting. Historically, there have been 3, but the sessions are for 5 full days. And so a lot of times in the past, you've had 3 weeks, 4 days each, right? So this department's experimenting, and they will be in person. The RISE committee proposed topics. I won't go through all of this in detail, but what you can generally see is what we're talking about that the RISE committee is going to look at are loan limits and the loan repayment stuff and loan rehabilitation, right? Like they're really focused on the financial aid nuts and bolts things that we talked about in the first 4 subtitles, right? Not so much the accountability, bar defense, close school loan discharge, those types of things. Okay. The one thing that is not on this page is Pell Grants. I just want to highlight that. Here's the composition. So, and I think this is really important to understand. When the department nominates folks to negotiate and sit around the table, they are obligated to request negotiators that will represent particular constituencies, but they have some flexibility in the constituencies that they select. And it's always worthwhile sort of understanding what the composition of the folks sitting around the table is going to be. There's some method to my madness here. So what you essentially see, this is each of the constituencies that will be represented in the RISE committee. The dark blue or the navy represents folks who come from the student perspective, student loan borrowers for veterans, legal assistance organizations, right? The green represent the institutional perspective, public, private, nonprofits, proprietary. So institutions will have 3 seats at the table, 1 sort of for each of the general sectors. The red is an agency, state agency officials, and then the orange is my wild cards, right? So we got student loan servicers and guarantee agencies, not really regulators, not really representing institutions or students per se. And then very interesting, and a new bucket, I don't recall this bucket before, organizations representing taxpayers and the public interest. So I would call that your wild card too. The AHEAD committee is the other one. The full name is Accountability in Higher Education and Access Through Demand-Driven Workforce, Pell committee. We'll just call it AHEAD. And they're going to consider changes to institutional and programmatic accountability, the Pell Grant program, and other changes to Title IV. I think suffice to say, the real focus here is what do we do with financial value transparency, gainful employment, and the do no harm framework. I think that'll be a major point of conversation for this committee. And then also the Pell stuff, that workforce Pell Grant program, like how do we actually implement this thing? Again, nominations are due by the 25th. Please note that the, you know what? I fear that is the wrong email address. My apologies. Please ignore that email address. That is the email address for the RISE committee. I will make sure that we get a corrected email address. We'll update the PDF, so we'll get that out on the wire. But again, if you go to the NEGREG website, the correct email address is there. You would probably guess, I think this is the consequence of me copying and pasting a slide. So my apologies for that inaccuracy. The AHEAD committee negotiators are going to meet in December and January of next year, again for 2 5-day sessions. Here's their topics in more detail, but again, suffice to say, it's pretty much accountability and Pell Grants. And here's the composition of the negotiators. So several things I want to point out, which I think is interesting. First of all, I meant to mention one group that was not represented on the prior or in this group is financial aid officers. And historically, financial aid officers in many of these negotiations have had their own seat at the table, and there is no specific seat allocated to financial aid officers this time around. You'll also notice that there are more boxes on this screen because there will be more negotiators at the table for the AHEAD committee. Again, you see a 3-and-3 split between organizations that represent students and organizations that represent institutions. You've got your 2 wild cards at the beginning, employer groups representing the business community, interesting, organizations representing taxpayer and the public interest. And where in the prior, we only had 1 box that really went to regulators, for the AHEAD negotiated rulemaking, you're going to have 4 regulators essentially at the table: state workforce agencies, state ed financing organizations, state authorizing agencies, and accrediting agencies. So very interesting that, you know, how these compositions change for these different NEGREG committees. If you want more information, here's where you can go. I think you can click on the picture here or the link. This is the department's NEGREG for Higher Ed 2025. You can also use that link to get to the Federal Register announcement, which has the correct email address for the AHEAD a head. I don't know if it's a head or a head. I think it's probably a head committee. So please make sure you get the right email address for the head committee. And again, my apologies for whiffing on that. So I mentioned we have our Regucation, which is our free resources platform. All of our stuff is here. The resources, we've written a blog already about, we did a little more on bar defense earlier. These videos, all of our webinars, everything is here. So you can click the link, you can just Google Regucation, or you can scan that QR code. I'm going to put it on the disclaimer, and then I'm going to try to answer some questions. How much flexibility, this is a great one. How much flexibility does the department have on accountability to fix the flaws you mentioned? Most of that is in statute. True, a lot of it is in statute, but keep in mind several things. Like a starting point at this NEGREG is, do we get rid of big chunks of financial value transparency? Do we get rid of gainful employment? I mean, Congress has authorized this specific idea now. Should we really be including anything that's not within the scope of the specific idea? So for starters, I think there's a huge scope conversation to be had. And then I think there are multiple decision points, which I'll talk about on Thursday, where meaningful changes or options can be created, potentially to address some of those apples to oranges types of concepts. But the person who asked this question is absolutely right. I mean, this framework is in statute, the do no harm framework. So that's another reason why it's going to be so critical in NEGREG for folks to be very thoughtful about understanding that the department has to comply with the statutory language. Where is the wiggle room? Where are the opportunities for the department to potentially move the framework in certain directions or implement it in certain ways or treat appeals? And I think there's a lot of opportunity potentially in that appeal bucket, to try to address some of these concerns. But it's true. They now, unlike with financial value transfer and gainful employment, the last 3 times that was negotiated, there was no statute on the books that was really driving it, and now there is. So it's a great observation. Let's see. Since they're doing NEGREG, what does that do to the implementation timeframes? Yeah, great question there too. So the department has some ability to implement interim rules, right? It can also, and then those can become final thereafter. It can also implement final rules ahead of the master calendar schedule. For those who may not remember, for the department, if it's creating rules that are carrying out statutes that exist in Title IV, and all the stuff we talked about today, except for the tax endowment changes, are inside of Title IV, right? If the department is carrying out regulations or implementing regulations to carry out Title IV changes, which is what's happening here, they're subject to this master calendar. And the idea is they have to have a final rule on the books by November 1 of any year for it to become effective by the following July 1. Now, at this point, on a traditional NEGREG schedule, that means the department at best would probably be looking at an effective date for its new rules of July 1, 2027, right? Because between now and then, there's no way they're going to get, a proposed rule. I mean, the NEGREG committees don't even meet until next year. So it's fair to say it would have to be, those rules would be effective on a standard time frame by next July 1, 2027, or not next, but the year after that. That being said, the department can early implement rules. It can't necessarily hold schools accountable, but where there are things that it has been directed to do, it can go ahead and implement those things as well, right? So even if it had a final rule on the books next year, let's say by November 1, but you still had all the time until July 1, 2027, schools wouldn't be bound in that interim period. They could voluntarily adopt, but the department could start holding itself accountable to those regulations and implementing as well. So there's the interim rule concept. There's early implementation concepts. There are things the department can do. The one other thing I've heard floated in different corners is this idea of, has the department implicitly authorized, has Congress implicitly authorized the department to sort of override the master calendar here by saying that certain things should become effective July 1, 2026. I think it would be, the department can do what it wants, right? But I think it would be a tough row to hoe in court if you have a statutory scheme that is express and explicit, and you are trying to argue that some sort of implicit directive from Congress overrides the explicit directive that is currently in statute, right? I mean, that's a tough argument to win. The department could still lean into it, but my guess is it is more likely that they're going to lean into interim concepts or self-adopting or early adopting concepts. The other thing is, keep in mind, I mean, again, that accountability framework in particular in all of this is enormously complex, and you got to go through rulemakings, you got to implement it. That takes hands on deck. And this agency is still under a directive, as I mentioned earlier, and as I'm sure most of you know, to diminish itself to the maximum extent allowed under the law. So I think there is a real question as to whether or not the department has the authority to staff up in the way that it would need to potentially to execute all of this by July 1, 2026. I just think that would be an extraordinarily tall order. I also think that there are places, including with regard to the accountability framework, and I'll talk about this on Thursday, where the department could actually implement in accordance with the letter of the law as of July 1, 2026, notwithstanding the fact that a lot of the machinery had not yet been built. And we'll talk about some of that as well. Let's see. How do requirements for institutional reporting differ? I don't want to do all accountability questions because we could do this all day on Thursday. But I'll just say the D&H framework has no provisions for reporting data. None at all. It's like a page and a half of text, so there's a ton for the department to have to figure out. But I also think what that means is that the department will be very interested in maintaining the financial value transparency framework, or at least the elements of it that involve data reporting and gathering, because they're going to need that. They've already got machinery that's been built. Why get rid of it, right? I think more likely is potentially them carving out some of the other pieces that aren't supported here. But I think they could say we have to have a data reporting mechanism. So I think that for schools that are facing this September 30 deadline, by the way, I would not assume it's going to be extended for gainful employment reporting, financial value transparency reporting. Maybe it will be, but this administration is defending that rule in court, and this law makes clear that they need the data. So it could be extended, but I would not assume that it's all going to go away. All right, let's skip to some of the other questions. Let's see. I'm trying to find some questions that aren't accountability related. Yeah, okay, here's a great question. We already have several, this is on Workforce Pell. We already have several non-degree programs approved through our state's workforce agency. Should I reach out to them about Workforce Pell? Yes, 100%, right? I mean, to the extent that you all have non-degree programs that are currently approved by your state authorizing agency, those programs have not have been approved by your, keep in mind the Workforce Pell thing that I talked about earlier, that program, to be a workforce program, right? It's got to be approved by the governor in connection with your state agency, and the governor has to certify, or somebody has to certify under the governor's auspices, that the program's met all those specific requirements. So I think it is fair to assume that right now there is not a single program in the United States that qualifies under this statutory requirements, right? Because I can't imagine that there are any states that have built this machinery, evaluated and approved programs. Not to mention that the department then has to also apply several tests, which include placement and completion rate analyses. So my expectation is the best thing you can do right now is I would talk to your state authorizing agencies. I don't know if anybody from NASAPS is on the line, but you guys should be watching out for this as well and thinking about it. I would talk with those state authorizing entities, those workforce boards. I would ask them if they're aware of this, if they're having conversations about it. If you've got state level higher education organizations, whether that be private, nonprofit, public, proprietary career schools, everybody should be working together to try to get your states, your governors, and your state agencies that are going to be responsible for this, building this machinery so they can start approving these programs, right? And a lot of you have a lot of clout. I mean, I would think even state flagships have interest in short-term Pell, like who doesn't? So a lot of folks are going to have connections to your governor's office and your state agencies. I would start trying to work with them. Not in an obnoxious way. I would not send them 1,000 emails at once, but yes, it's time to start that conversation. And I would not assume that because your program has been approved already by one of those agencies and meets the time requirements and clock hour requirements that it's going to somehow just be automatically qualified. I find it very hard to believe that could happen. I think that agencies are going to have to work with the governor to develop a new framework to evaluate or reevaluate any program that may be out there. All right, let me see if I can find at least one more. I know we're at the bottom of the hour. Let's see. Oh, so is there any interest in specifying in regulation that workforce Pell Grant programs have to be at one sector or another, at nonprofits? That is not how Congress designed the statute. So I don't know what basis this department would have for trying to limit the availability of workforce Pell Grant programs. And I don't see this administration as having an interest in moving in that direction, candidly. All right. We're at the bottom of the hour. I apologize I didn't have more time for questions, but hopefully this was useful to everyone. If you are interested in the accountability stuff and you're not registered for Thursday, I would invite you to join me because, again, we're going to start out sort of recapping what it says, and then I'm really going to get into the weeds on a lot of it. And actually what I'm planning right now is to sort of the back half. The way I'm going to get into the weeds is to talk about, exactly what that first question was to that questioner about where is the wiggle room and what do we think the potential opportunities are for negotiators at the table to push for regulatory constructs that would be favorable for institutions and help make more sense out of this thing, So that's really the way I'm going to sort of frame it and sort of talk about it. And if you're a potential negotiator, please tune in because I would love for you to see this. Or if you're a negotiator a month from now who's watching this on YouTube, please go find that other video and watch it. Otherwise, look, I thank everybody always for joining. If you got a minute, do the post webinar survey. We always appreciate it. Otherwise, keep doing what you do. We so appreciate supporting higher education. It is a tremendous service that you are providing to your students and to our society. These are challenging transitional times for many, many, many reasons. So please keep the faith and know what you do is so valuable. And otherwise, I'll just say until next time, be well.